Hey, hey, hey. All persons having anything to do before the Honorable Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Massing. To my left, Justice Desmond. We are your panel for this morning. We will be hearing 4 arguments this morning. The rules are familiar to those of you who have been here before, but I'm not sure if everyone has. 30 minutes of argument, 15 minutes aside. There is no rebuttal. And if a side is dividing its time either among more than one appellant or more than one appellee, they should let us know at the outset. The first case we will hear today is a partially impounded case. Hold on. The defendant's name is not impounded, is it? Okay, so it is number 22827, Commonwealth versus MENJARES, and as there is an impoundment order in effect, and I assume you're both familiar with its scope, please adhere to it in your argument and not use whatever aspects of this are impounded. So, having said that, we will hear first from Attorney Alpert.
Good morning. May it please the Court, Caroline Alpert for Mr. MENJARES, who is present here today. This case comes down to the aggregate and pervasive errors by trial counsel.
Can you move the mic a little closer to you?
Yes.
Thank you.
This case comes down to the aggregate and pervasive errors by trial counsel that all impacted the core credibility determination. The evidentiary portion of the trial took only 1.5 days, and there were only 4 exhibits. But there are errors with nearly every witness and nearly every exhibit. This was not an isolated, fleeting mistake.
What do you think was the most egregious error?
There were so many, but I will start with first complaint, because I think this was a theme that really came out throughout the whole trial, which is that the Commonwealth elicited evidence of multiple complaints. They discussed it in their opening, they brought it out in their case in chief, and then this was a huge theme of their closing. The main thrust of their closing was that because she had been consistent over time to multiple parties, that therefore she was credible. And this is the exact type of argument that King expressly forbids. In King, they replaced fresh complaint with first complaint to prohibit this exact type of argument that because someone repeats themselves over and over, they must be telling the truth. And this was a huge part of the case. And regardless of trial counsel's plan to elicit what he says were inconsistent statements, there's still no reason to first let the Commonwealth elicit consistent statements in their case in chief and use them in that way in closing.
Do you agree that if that was trial counsel's strategy and the strategy fails, that doesn't make him per se ineffective?
Sure.
Or that doesn't constitute per se ineffectiveness of counsel. I guess it was ineffective if it failed, but doesn't make him per se ineffectiveness of counsel.
Right. The question is not did it fail or succeed. The question is was it reasonable at the time based on the information he had. And so again, even if he's thinking to himself, okay, I have these particular inconsistencies I'm going to bring out on cross, why would you let the Commonwealth first bring out and highlight all of the consistencies? That doesn't really make any sense. And then moving into what he claims to be inconsistencies, when we look at them, the majority of them really weren't. It was most of them were consistent, and again, the way that we can really see this is by looking at his closing argument. In his closing argument, he points out really 2 inconsistencies regarding the report of the sexual assault. First is the one, the comment made to Matt Mays, that she woke up with his hands down her pants. But Matt Mays was the proper first complaint witness, so that was going to come in regardless, so fine. He then seems to claim that her comment to one of the officers that she may have been penetrated was inconsistent. I still think that's consistent because her testimony at trial was that She woke up the next morning, something didn't feel right, thought she might have had sex. And so I think that that's consistent. But even if you don't agree with me on that, what about all these other statements to Carla, to Denise, to the other officer, to the EMTs? He didn't do anything to actually use those or highlight any inconsistencies in his closing.
Doesn't the Commonwealth argue that there are several inconsistencies in their closing?
Well,
He talks about different people have different timelines, or she, I apologize, I think it was she. Was the
sure,
prosecutor.
there are other inconsistencies that come out about other facts, about the timeline that doesn't make sense. Trial counsel seems stuck on this issue about her shorts on one leg or another. Does that make sense? But none of that focuses on the issue of what is he trying to get out of multiple reports? And what we know from King and its progeny is that multiple reports piling on, as they like to say, is highly prejudicial. So there needs to be a specific reason that you're bringing that in, and you need to marshal it.
You agree that in this case, there's no dispute that something happened, the only issue is consent, right?
Correct. And so it's prejudicial and unreasonable to bring in reports that are bolstering and vouching for her version of events that there was not consent. But there's so many issues here, and I do want to make sure we get to other ones because there's a lot, and I think the court could find ineffective assistance even if they don't agree with me on everything. So moving on, the next one I think that's particularly egregious is all the evidence that came in about official confirmation in the that there had been a sexual assault. So looking at the exhibits in particular, so first we have Exhibit 1, which was the medical records, and what happened here is the Commonwealth goes to put this in as an exhibit. The judge very quickly starts flipping through it and immediately finds several instances of the phrase sexual assault, which we all know under Dargan has to be redacted. And he says, hold on, why are these in here? They need to be redacted. The Commonwealth says, oh, whoops, let me go redact those. But that doesn't then get trial counsel to think, oh, I better go look through these again and make sure this phrase is not in there. He still doesn't look at the records. The records go back in with the redactions that the judge pointed out, but there's still several instances referencing a, quote, sexual assault, which is just per se inadmissible. There's no reason that ever comes in. It's just error. And I can't think of any reasonable strategy why trial counsel would want to leave that in there. Then we have Exhibit 4, and this one's just bizarre because the Commonwealth puts this in saying that it's the buccal swab results, and the first page is, in fact, the buccal swab results, but then there's all these other pages attached to it. We have other forms from the SANE exam. One of them includes the entire narrative from the complainant to the SANE nurse, where the SANE nurse refers to Mr. MENJARES as the assailant multiple times. Then there's a motion from the Commonwealth requesting, quote, the rape kit. And I also want to note at this point that the Commonwealth used the phrase rape kit in opening, in direct questioning, and in closing. That's not supposed to happen. And so again, I can't imagine any strategic reason to let this kind of phraseology be used at a trial where the defense is consent. And one other point on this is also there was testimony from the SANE nurse that in order to have a SANE exam, there must have been a sexual assault within 5 days. So again, from multiple angles here, we have official confirmation that there had in fact been a sexual assault. Dargan says this has to be redacted. Trial counsel has not explained any reason why he let this in. Moving on, then we have this issue with calling Mr. MENJARES' girlfriend as a witness. What trial counsel said is he called her to impeach on this issue of whether or not there was a party that night. But that's really a collateral issue in this case. And what happened is that what came out on cross is that she had lied to Mr. MENJARES. And sorry, backing up, because another important point here is that on the record in the transcript, the prosecutor says, I want to talk to Miss Murcia, the girlfriend, before she testifies. The court says, okay, fine. But trial counsel didn't participate in that interview and didn't find out what was said to the prosecutor during that interview. So he now calls this witness without having the proper...
Does he have a right to sit in on the Commonwealth's interview with the witness?
He doesn't have the right, but you would think it's his defense witness. He would at least ask her and try to find out what was said, because that goes into your strategy about whether I'm going to call this person or not.
Do we know that he didn't talk to her after the Commonwealth did?
I believe in his, well, so there's two affidavits here. Affidavit of trial counsel says that he, in his, that's right, he and his did not comment on this. I did also put my own affidavit based on conversations I had with him.
Yeah, I was a little bit, I thought that was a little weird.
Yeah.
You include, like, he won't, obviously he disagreed with you on what could be in the affidavit. And so you give us his hearsay statements of what he told you, but that he refused to sign. Can we really consider those?
I agree. It was kind of a strange situation, and I felt that it was important to include how I could, what he had reported to me on the phone. But if the court doesn't want to accept that as fact, then that's
We can't,
okay.
right? I mean, it's hearsay. You can't. You want us to accept for the truth of the matter asserted.
Okay.
But we can't accept it for the truth of the matter, maybe. I'm not sure, but maybe. But we constantly deny claims of ineffective assistance, saying that there's no affidavit from trial counsel nor any record of an attempt to get one. And so to the extent you describe your attempts to get an affidavit, a more complete affidavit from him, we could presumably consider it for that.
I would hope so. And I think even if you don't want to accept my affidavit, in his affidavit, he doesn't say anything about this particular interview. And so I think the fair assumption is he doesn't know what was said in that interview. And I think that would be an important thing you would want to find out before you call the witness. But even setting that particular decision aside, what happens here is the Commonwealth then on cross of Ms. Murcia gets out the fact that Mr. MENJARES had lied to her. And then in closing, the Commonwealth uses this to say, well, he's lied to his girlfriend for a couple of years. That speaks to his character. How do you know he's not lying here today? That is just patently inadmissible. People are not allowed to make that type of argument, but no objection from trial counsel. And this leads to this other.
Before we move on to
Yes.
that, while we're on the topic of affidavits, the Commonwealth points out that there is no affidavit from your client. Is that important one way or the other?
I don't think it's important here because I don't think there was no information that could come solely from him that was relevant to any of these points here. We're looking at what.
Well, you make an argument about his level of intoxication, right?
Yes, but there was sufficient evidence of trial. He testified at trial. So we have him on record discussing his clear intoxication, which is also corroborated by all of the Commonwealth witnesses.
I'm not so sure that that's what he says when he's cross-examined. He says, you could say I was drunk, or some words to that effect. It doesn't seem definitive.
Okay, I'll go back and double check that, but my reading of the transcript is that there was a lot of evidence that all the people at this party were drinking, were using various drugs. The complainant herself testified that she smelled alcohol on his breath. So there was certainly evidence of consumption of substances, and what trial counsel said in his affidavit is that the reason he didn't request the intoxication instruction, is because there was no evidence of intoxication. That's just wrong based on a very simple reading of what happened at trial.
But in that one, didn't counsel wanted to argue that he knew exactly what he was doing? He was having consensual sex. He wasn't so drunk that he didn't know what he was doing. I mean, if he doesn't saying that he's intoxicated and that he didn't know what he's doing sort of run contrary to the defense?
Well, no, I think it actually goes with the defense, because what Mountry discusses, and it discusses this exact issue, is that when the Commonwealth, if one of the elements they have to prove is lack of consent, that puts a knowledge element on the defendant. So he has to know that she's not consenting. And so the fact that there was evidence of intoxication, I think if they're claiming she can't consent, I think it would be consistent to say, well, even if that's true, he was drunk too, so he you don't meet that knowledge element. And so I think they can work together.
But doesn't that cut against his testimony, which was it started off consensually and then she withdrew the consent? I mean, if he's too intoxicated to know, how can he say that?
Point taken. But I think
Yeah, but you don't know. I don't know why the point is taken. It seems to me people can act all different ways. A drunk person who can't tell that something is a manifestation of lack of consent, when the manifestation gets stronger, may recognize it, even while drunk, it seems to me. I mean, he's not too drunk to have the sexual contact, whatever it was. But I don't know.
Yes, no, and I agree, and I think that's the point I was originally trying to make, that I don't think these are mutually exclusive. I think that someone can be intoxicated and believe that someone is consenting, and the other party who's also intoxicated later claims, well, I was too drunk to consent. And the person's understanding of how drunk they were, I do think their intoxication impacts that as well. But regardless, what's concerning here was trial counsel's explanation for this, which is that he didn't ask for it because there was no evidence of intoxication, which is just not true. And so I'm really not sure what's going on there, but that's certainly not a strategic decision by counsel.
So should we, obviously you want us on this record to say that you've proved ineffective assistance of counsel without even an evidentiary hearing. Would another option be an evidentiary hearing where you could actually cross-examine defense counsel based on the things that didn't you tell me, and find out more about all of this stuff?
I don't think an evidentiary hearing is necessary here because no one is disputing any of the facts. In the motion for new trial, what the Commonwealth said is, we're not disputing the facts, we accept the affidavit in full, we don't need a hearing. And then the court said, okay, we don't need a hearing, and in its written findings, the court said, I accept this affidavit in full. And so I don't think there's much else to be gleaned from an evidentiary hearing at this point.
Okay, your time has expired, but if there are further questions, I see none. Thank you very much. Excellent brief, excellent job. Thank you.
Thank you.
Very helpful. We will hear next from Attorney McGowan.
Good morning. Excuse me. Good morning. May it please the court. ADA David McGowan for the Commonwealth. I'd also like to acknowledge ADA Brooke Hartley's work on the brief that's been submitted to the court. We expect her to return to the office early next year. I'd like to start initially to the redactions. My sister said that counsel was ineffective for failing to look at them before they went to the jury.
Well, we know he looked at them. I mean, because the prosecutor says, that's my fault, Judge. I should have redacted those, or I should have caught those errors, and I didn't. So it seems as though he had met with the defense counsel prior to the court reviewing those documents. He just didn't do a final review, perhaps.
That's my point, Your Honor. At that point, I believe, is in Volume 2. In Volume 3, prior to closing arguments, the counsel states to the court, I have reviewed those with my assistant.
He assented to the admission of unredacted documents?
He did. That's at Volume 3.
Okay, so that seems bad, doesn't it? That seems like a substantial failure.
I disagree. I think under Darger, my sister is right that those certain redactions need to be made, and when they're not made, they can be considered error. However, that's not the end of the analysis. In this case, this defense attorney had a very particular strategy, and just because it fails doesn't mean it was ineffective or manifestly unreasonable. In this case, it was to use all the statements, some of which overlap like a Venn diagram and have aspects of consistency. But the omissions were also used by the defense to show that this woman, this complainant, had one version, and it changed over time, and it changed on the stand.
Not in any substantial way. These are not helpful second complaints, and I'm not talking about second complaints and third complaints, but they're not helpful to the defendant to hear, no, it was hands down the pants, not just up the shirt, no, I was penetrated, but I wasn't. These are, the broader question is, was she sexually assaulted? And we're talking about the redactions. And I agree that he agrees, the defendant agrees at trial, there was sexual contact. But why is it okay to allow, it's clearly error, but why isn't it ineffective assistance to allow the jury to hear that the medical records say repeatedly that it's an assault? it's a sexual assault, and we even have the nurse's diagnosis about assailant, I think, at one point, and she says we do this when there's been an assault within a day or 5 days, or I don't know what there's something she says like that. How can letting in this stuff that says sexual assault all over it? I mean, you wouldn't let that stuff in if you were defense counsel, and neither would I.
No, I wouldn't, and I'd like to say in the sexual assault trials I've had, I've tried to be diligent under Dargan to make those redactions. However, in this case, the defense attorney used some of that to his advantage, in particular, the sane nurse at page 147 of volume 2. You're a neutral person in this, correct? Just your job to collect the evidence. So what he's juxtaposing is the forms themselves that have those titles that should have been redacted, but they have those titles, and that you're just collecting evidence.
But she calls the person an assailant. She's a neutral person, she calls the person an assailant. I mean, I have to say, I haven't seen, the fact that the big red flag for me, or first one, is the lawyer was gonna let in everything wholly unredacted. And I hear what you say, maybe they had an agreement, although it's not totally clear to me. Maybe they had an agreement, they had gone through the redactions, and the defense counsel prosecutor didn't make them. But that's not what it sounds like. They have to now go to sidebar and look through the documents, and the defense counsel does not make sure these are completely redacted. I mean, why redact any of it?
Well, there's substantial redactions. So
I agree with that, but there's substantial omissions from the redactions, too.
Correct. And the title of the form, it's hard to say that is manifestly unreasonable, and if so, in some ways drastically prejudice the defendants on these facts. I'm sure there are iterations of facts that could make this far more problematic, but on these facts, certain redactions were made under competent, experienced counsel, made strategic decisions to redact those. One of the things in his affidavit on Record Appendix 50, he indicates that I make certain objections, but not all, because I don't want to alienate the jury. Redactions are objections. They're obviously objections, and what the defense was doing was picking his spots. I think artfully based on the hand that he was dealt in this case.
So let's say that makes sense. I'm going to ask you to address the Attorney Alpert's reply brief, which is, okay, so maybe that one standing alone is not fatal. But there are several other concerns that I think even you acknowledge. So cumulatively, how is he not entitled to a new trial?
Part of this is, was the performance of the attorney so manifestly unreasonable that he was deprived of substantial ground of defense? In this case, the defendant on appeal makes no alternate defense. The defense was consent from beginning to end. The facts required that. And so in no way was the defendant deprived of defense. What the defendant is currently saying is it should have been done differently.
The prosecutor said, erroneously, you should consider whether he has a character for lying when you are deciding whether he's lying. I mean, I teach evidence. It's like the second week, right? And I'm not saying, look, prosecutors make mistakes, people make mistakes, blah, 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 but there's no objection.
There isn't, and I think the only offending word there is the word character.
Yes, but that's the offending word.
And it sure is. In response, the reason there's no objection, based on my reading of the record, and again, the fullness of these decisions wasn't fully fleshed out, and I agree with my sister, don't need to be based on counsel's affidavit of how he chose to exercise objections or not raise them. In this case, the defense theory in the closing is, my client is a terrible boyfriend, he is a terrible fiance. He's owning that. So the fact that he lied is something that he's accepting and owning.
No, wait a minute. This is a credibility fight. The idea is, the question is, which of these two people is credible?
Correct.
And this is not about whether he's a bad boyfriend for cheating on his girlfriend or whatever it is you want to call this. I don't know if you'd call, I don't know what you call this, but having sexual contact with someone not his girlfriend. I don't know the bad boyfriend is, but whatever.
Understood.
A bad person or something for engaging in this. But But the point isn't that he's a liar, and so also don't believe what he just told you on the stand, right?
No.
Okay.
My client is guilty of being a bad boyfriend. Okay. The reason he's saying that is he's referencing the decision that his client made and that he says in my sister's affidavit in support of the motion for new trial that I knew she would say he didn't tell her. That was at paragraph 15. So he knew what she was going to say on the stand, that it was an untruth, that he didn't tell her until over a year later, I think a year and a half later. And then he said, yeah, something happened. And now it's consensual. So he has to own that timing. And so that's what he's talking about. And that's what the ADA and the closing was saying, should not have said character. But she's saying he was lying before, he could be lying now.
I'm sorry to interrupt you, but I just want to make sure I understood your point. Did you say that he knew, he called her specifically to say that,
No.
that there wasn't a party and he
No.
knew what she was going to say?
He knew, well, the purpose of calling her was to show that prior to what was substantial alcohol consumption on the part of the victim, that she was already inconsistent. And then he used the inconsistencies of all the statements and drug and alcohol consumption to further cast doubt on her account of what happened, her credibility. With respect to Record Appendix, page 53, paragraph 12, Attorney Kelly stated that he was aware prior to trial that Mr. MENJARES had denied the incident to Ms. Murcia. Okay. Further down, with respect to paragraph 15.
So I just want to stop. We're relying on Attorney Alpert's affidavit here.
That's the page, yes.
Okay.
I mean,
So you have no objection to her statements of what the hearsay of what he said. In fact, you're using them.
I find it odd. It's in the record. I'm citing to it. I don't know
It wasn't
if I necessarily
objected to.
agree
It wasn't objected to below or struck, though, right? That affidavit by.
I don't believe that affidavit, and I could be wrong. My reading was that it was Attorney Kelly's affidavit that was the only thing relied on, not Attorney Alpert's. But
Attorney Alpert's. Oh, I see. Attorney Alpert's is. No. It says it's in the Chelsea District Court. It doesn't say it's here.
no, I believe that affidavit was filed in support of the motion for due trial. Yes.
Okay.
Anyway, and
So
you're
in terms
relying
of
on it.
what was agreed to for the purposes of a motion for due trial
Oh,
hearing.
yeah, no, not agreed to, but not objected to on grounds of hearsay, and not struck from the record because it was inadmissible.
I don't believe that occurred, but I also don't believe when the motion judge said, this is the record, I'm going to credit this affidavit, that my sister's affidavit was included.
No, I agree. I think I say I agree. My recollection is the judge credited only the defendant's, the trial counsel's affidavit.
That's mine too.
Yeah.
That's my memory.
Okay.
So I guess to answer the court's question, it's in the appendix. I'm drawing attention to it because it clarifies specific questions from the court. I'm not now advocating it should be part of the factual record and treating it as such.
Was it proper for him to comment on his arrest? Was it proper for the Commonwealth to comment on the arrest of the defendant?
With respect to Officer Serrano's testimony, Your Honor,
And they use it in the closing as well, right?
I think that's inadvisable. I think if there were an objection, I think that likely would have been sustained. I think what Attorney Kelly said in terms of his rationale for not objecting is that I only want to object when it matters. Of course he was, I'm now inferring from his affidavit, of course that is a fact. In their opening preliminary instructions, the court instructed the jurors that a complaint is nothing more than a piece of paper. So
I get it. So let me just ask you this as we're starting to run out of time a little bit here. Cumulatively, what do you think?
I think this is Monday morning quarterbacking of a reasonable strategy. I think one dictated by the incontrovertible facts. This DNA evidence is very devastating to the defendant. He didn't know it at the time he made statements or did not tell his girlfriend. When that evidence came to light, he and his counsel had a tough hand to play. And the best hand, in my opinion, I haven't done this for a little while, is the consent defense. The intoxication defense, not only is it not supported by the factual record, it totally undercuts this consent defense because under the defendant's own testimony at trial, he says the oral sex, the incident in this place lasted mere seconds. So to have the fine acuity and the lack of intoxication to identify proper consent, and then not have it seconds later to properly recognize the withdrawal of that consent is simply a laughable defense, in addition to not being factually supported, where you need to show debilitation. And I believe the court, Volume 2, pages 37 and 38, says absolutely there isn't enough here. The defendant saying he's coherent, that he did have something to drink, but he understands exactly what's going on, and that's the defense. So this was discussed on the record in this case about choosing which path to go. And based on the evidence here, that was the only path. But as Your Honor pointed out a moment ago, just because it fails doesn't mean it's Just because it's ineffective doesn't mean it's ineffective assistance of counsel. And that's exactly what happened here. This was a tough case for counsel and made a lot of hay with what he had. Had he stood up and popped up at every objectionable moment, he may have alienated the jury. That's a reasonable observation.
That doesn't apply to the documents that are going in. He could, a discussion of what's redacted doesn't require popping up in front of the jury, right? That could have been done without alienating the jury.
That was done outside of the jury, correct.
Right. So that doesn't apply to the documents that came in.
No, it doesn't. But when a jury are in the back deliberating over the exhibits and sees a lot of black or big black squares, it's obvious what's going on there. And I don't think that's divorced from the analysis of whether you are making objections. But Your Honor's making an obvious point. It's not the popping up and down.
You know, so the case law says you're not supposed to have references to sexual assault or assailant. Case law says you're not supposed to, not supposed to let the police officers put their imprimatur on the arrest, even though we all know that the victim did, make these claims, and we know that the police did believe the victim because here we are in the courtroom. But nonetheless, the law gives defendants these advantages. You don't have, you can get that stuff out. So what's the strategic reason to let those things in that you don't have to let in when they only kind of hurt?
What I think happens,
it just piles on.
From looking at this record, what I think is going on is the the defense counsel used to great effect the initial relationship with the victim and the defendant, talking about their relationship, talking about her prior relationships. My sister complains about her orientation being used, but part of the evidence that came out was her prior boyfriend not being a great guy, she can do better. Made big hay of the emotional connection of the two of them, and then it went differently. And so part of showing the reaction that she had, the overreaction either due to drinking or the drug use, is something he's not hiding from. A different attorney could look at this and have an also equally as reasonable path to redact. But because the question here is, was this counsel reasonable in not insisting that those portions were blacked out?
How was it?
No, go ahead.
How was it helpful for him to allow the Commonwealth to, in their closing argument, to talk about how intrusive the exam was and what she had to go through in the course of the exam? How does that come in?
Well,
For any purpose?
He could have objected. He chose not to. I think it's the prosecutor responding to the defendant's argument in closing that to be charged with sex crimes are awful. They're despicable. And then he says, to be charged falsely was one, maybe even worse, or is just as bad as the language. So responding to how awful it is to be charged, and his argument was falsely, I think there's a juxtaposition here of the two arguments. And that, I think, could have been crafted differently. I think there's all kinds of, these cases are very difficult to have perfectly articulated closing arguments. That doesn't relieve us from the burden to get as close to possible there. But in this case, on these facts, as this case was tried, I do not think there is reversible error with respect to that statement, particularly as it touches back to exactly what the defendant was trying to do himself.
I'm all set.
You all set? Very good. Thank you very much. Very well argued and well briefed. Very helpful, both of you, to us. Very well presented case. The case is submitted. The next matter we will hear is number Like I should know, right? Yes. 23-26. It too is partially impounded, and we would appreciate if you adhere to whatever the scope of that order is. It is Commonwealth versus Tatro, and we will hear first from Attorney Peterson.
Good morning, Your Honors. May it please the Court. Just to let you know, none of this is impounded. This is not an impounded case. It is a fully public case. That being said, Your Honors, tomato, tomato, potato, potato. That's all I could think of while I was reviewing this case. That is the Commonwealth's argument, is that the words encounter and contact are interchangeable, and they're not in this particular case. This case is basically a one-issue case, and that is it. It's that the jury instruction that Justice Franks gave in court was improper. It included both terminologies. This was a harassment prevention order violation.
There was a video entered, right?
There was a small video that was introduced, stills, Your Honor. But basically, the facts are, and I'm sure you're well aware, is that my client goes in to Walmart behind the victim. That's not the violation. The Commonwealth is going to argue throughout the case that it is two things. It's my client within close proximity of the victim, as well as the defendant's sister screaming at the victim.
But the judge told the jury, you can find the defendant guilty only if he was within a certain distance of the person with the protective order. That's the instruction of the judge. So they aren't told you can convict him for anything else?
They're not, Your Honor. Actually, I don't believe that, Your Honor, because that's only part of the instruction. That's the violation part, right? That's what he says. It's the distance we're going at. But then in the supplemental instruction, he keeps using the words contact or encounter.
He does say contact or encounter, contact or encounter. You're saying a reasonable jury wouldn't have thought that meant, you know, the thing where she's within 100 feet, call it contact, call it encounter.
No, Your
You're
Honor.
saying that they would have, but they weren't instructed what is contact?
They weren't instructed what's contact. They weren't instructed what encounter is, Your Honor.
Well, what I'm saying is, so when they hear the word contact, it's not like they're thinking, oh, yeah, he said contact is, you know, whatever it is, you know, I don't know, calling her, sending a message to her, what, you know, I don't know what
Touching
the definition of touching her. I don't know what the definition of contact is, but they weren't told anything about it. So when they heard the word phrase, contact or encounter, you're saying they would have still thought she could have contacted him.
He would have contacted her, Your Honor. Yes.
I mean, I'm sorry, backwards,
That's
He contacted her.
That's correct, Your Honor. Because that's the Commonwealth's argument the entire time, right? Pre-trial.
Don't argue it.
But, Your Honor, though, but what happens is, right, that the jury never hears the word encounter through any of it. They've never heard that word encounter. They've only heard contact. And the judge has told them, you can find this person guilty on contact or encounter if it's accidental. That's the only time they have heard the word encounter. It has been drilled into the jury's head.
What were they told about contact during the trial?
They've been told it from the judge's instruction, opening instruction. They've been told it from the Commonwealth throughout, because the Commonwealth tells the judge pre-trial, look, this is what I'm going to argue.
I'm not interested in what he told the judge. What did the jury hear that would have led them to think there's a thing, contact? It's not being within 100 yards, and we're being told by some lawyer, I guess, that that's a violation. Is there a place, because I didn't see you cite a place where they'd been told that by anyone. It certainly wasn't argued by the Commonwealth did have what I think is probably an error, this one error in the closing where they sort of bring up what under the instructions is irrelevant with the sister yelling or whatever, you know. But I didn't see a place where the jury where a lawyer said to them, and this is either this is contact and that's enough, or this is not contact. Was there anything like that during, I mean, it's not, there's no place for literal argument during the trial.
Well, during the opening argument by the Commonwealth, the prosecutor does say to the jury that they are together, the defendant is in Walmart with his sister, and with his sister yelling at, that's one. It is in the witnesses' statements regarding contact. It is in the harassment protection order that is admitted into evidence.
I don't think the
closing
judge did say that was off limits. I think that when the judge sort of directs out the contact theory, he says, but these things that happened with this, when the sister was yelling at the plaintiff and was not leaving, is relevant to whether he was there accidentally or not. So, I mean,
It's relevant, and you know what, Your Honor? I think the judge draws a very precarious line when he does that. I understand where Justice Franks is coming from, but then the prosecutor takes that and runs with it. And by that, she argues in her closing that it is entwined together, that contact is the same thing, Your Honor. And I think that becomes the perfect storm of this argument.
Is there evidence that when the sister was yelling, that the defendant was more than 100, whatever it is, feet or yards from the victim?
I believe the testimony is that he is within the 100 feet, Your Honor.
Within?
Within. He is within.
So I'm having a hard time figuring out. You're hypothesizing that the jury concluded, oh, he contacted her, he had his sister yell at her, but he wasn't within 100 feet of her. We'll convict on the contact theory.
That's the whole problem, Your Honor. It's because it's a general verdict that it comes back.
Okay, but I just asked you how they could have found that. Like, what would they have to have believed?
For contact or an encounter, Your Honor.
Is there anything in the evidence that would support a conclusion by the jury, he contacted her, but he did not come within 100 feet of her?
No, Your Honor.
Well, then what are we talking about? How can this be an error?
It's because it becomes a general.
The general verdict, the problem with it is you can't tell which theory. You're telling me, there's no evidence supporting only one theory.
But the case law states, Your Honor, that if it's a general verdict, we need to know which one they came down on. Because if the evidence does not support
If there's evidence,
contact,
I mean, I'll have to look at the case law. That seems odd if there's no evidence supporting one of them.
it doesn't matter if there's evidence supporting one of them, Your Honor, if the evidence doesn't support the other one, and we come back with a general verdict, then that is
We have to hypothesize that what they found was something they couldn't possibly have found.
Yes, if the evidence does not support contact and they came down with both, Your Honor, then it's not good enough.
Doesn't the Commonwealth say in their closing argument that, ladies and gentlemen, the Commonwealth submits to you that the defendant, being in this very short vicinity from Ms. Carpinelli at the Walmart, after already having seen her once when she entered in, being much less than 100 yards away from her, constituted the act? Mm-hmm. Don't they specifically tell you that it's within the 100 yards is the act that they're relying on in the closing argument?
That's right. And if we continue on in that argument, Your Honor, the Commonwealth then goes on to include all the sister's actions and how they're yelling at them together, and the sister and the defendant are standing side by side, yelling at the complainant as she goes by. The prosecutor ropes both things in together, once again, just like they said pre-trial they were going to argue, just like they did throughout their case, and just like they did in the opening argument. Nothing has changed from the prosecutor's argument. Their theme continues, and that is the crux of this case.
The theme continues. Think with your common sense. How big of a space is 100 yards? Take the time to visualize that. The focus is only about a half a page left of his argument, is on the 100-yard distance. You disagree with that?
I don't agree just with that, but it just continues on. That's just part of their opening, part of their closing. They continue with this entire theme. You know, and you know, Your Honor, I always try to sit back and I try to look back what a reasonable juror would do, because we know what the entirety of the instruction looks like. We know what was left out, that the contact language was left out. But we have to listen to what the jury actually heard. They never heard the word encounter. They only heard contact.
I asked
only
that
time
you
they
find
heard-
the defendant guilty of violation of a harassment prevention order because on May 24th, 2021, this defendant was merely feet away from Ms. Carpinelli after already having seen her once at the Walmart in Tewksbury, merely feet away, and he continued to make eye contact with her while an argument ensued.
That may all be true,
Then
Your
is
Honor.
it to focus on the distance?
No, and you know what? They may have, but they roped in that third-party contact, which they weren't allowed to do. And they kept doing it, and that's the confusion. You know, the judge everywhere else where it says he, parentheses, she, parentheses, put it as he. He left out the other one. Or were and was, left the other one out, did were. It is only with the encounter and contact. I mean, it's the judge's job to tailor these instructions so that they are heard and understood by the jury.
Right.
And again, I look back and I think...
No
if
objection, right?
Pardon?
No objection, right?
No objection, Your Honor. I mean, you know, and this attorney, I will give the trial attorney credit. You know, this was one of her first cases that she had done. She had tried in the court. It was her first violation of restraining order or harassment protection order. And she was very forthright that, you know what, I probably should have. I should have argued, I should have objected, or at least made the judge tailor it, or gone
But at the
back.
time, it sure sounded like tomato to me.
It did, and you know what, and that's right. But, and it's, you know.
I mean, but right, so, I mean, at the time, hearing it, knowing the history and that the judge had just said it can only be based on the 100 feet, contact encounter, hearing it didn't set off any bells. The word encounter, you're right. I mean, why do you think the word encounter is there in those instructions? There's no, like, it's not an element, there's stay away, there's, you know, there's don't harass, there's don't contact, but there's, what is it, I mean?
Personally, Your Honor, I looked at all these cases. I could not even find the word encounter. So if Your Honors can kind of change this jury instruction, we'd appreciate it. But that being said, you know, I don't think the encounter word is used a lot. I think if it was contact, but it was explained to the jury a little better, it would have made more sense.
I mean, the encounter has the advantage of being, well, you know, tomato. It's like, this thingy, whatever happened, whatever is charged with, that's the thing. And if it wasn't accidental, you know, the Commonwealth has to prove that it wasn't.
Yeah, and the problem becomes, too, if you look at the closing argument, right? You know, the Commonwealth submits that the defendant, however, along with his sister and another individual, intentionally approached the complainant. Like, so it's that grouping together, but that's, I think, what the encounter is. It's the, you know, whether the victim passed him by, you know, he should have left the Walmart. He should have left the Walmart. But the jury doesn't get that. The jury doesn't get the full breadth of this.
So what if the jury gets this? Now, ladies and gentlemen, if there's evidence that suggests that the defendant got within 100 feet of the complainant by accident or incidental to some lawful activity, the government must prove one of two things. Either he got within 100 feet by accident, or he failed to take reasonable steps to get away from 100 feet. Isn't he worse off if that's what they hear?
No, Your Honor, because that's the distance, right? That's the distance.
But he's clearly within 100 feet.
But now we know he's convicted on the right theory.
Yeah.
And that's what we want. We want fairness, we want justice, we want absoluteness. And that's all we're asking for in this case. It was just a host of a perfect storm coming together, and no one did the checks and balances, sadly. And if there are any other further questions?
Seeing none, thank you very much.
Thank you, Your Honor, appreciate it.
We will hear next from Attorney Spate.
Good morning. May it please the Court, Helly White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The general verdict is only a problem if more than one theory is actually before the jury, and that simply was not the case here. It's true that at the outset, the Commonwealth thought maybe they could prove third-party contact because there was evidence that the defendant spoke to his sister before the sister started yelling at the victim. The judge, and we could argue about whether that was sufficient, that could have gone to the jury or not, but the judge ruled at the close of the Commonwealth's evidence that that could not be argued, it could not be presented to the jury, and he was not going to instruct on third-party contact. That being the case, where the only theory before the jury is that the defendant came within 100, it was 100 feet, 100 yards, I don't remember which, of the victim, there is no risk of confusion. The only confusion, I think there is a risk of confusion if you are someone with legal knowledge looking at the two words contact and encounter and striving to distinguish between them, knowing that there was a theory that the judge ruled could not go to the jury, then it looks confusing. If you're a juror who has merely heard the evidence and has been told by the Commonwealth's closing that the defendant violated the order by coming within 100 feet of the victim, instructed by the judge that the basis for the violation was violating that proximity rule, you're not going to be confused by that distinction.
So what does a juror hear? When a juror hears, if there's evidence that suggests that the alleged contact or encounter may have occurred by accident, what does the jury think contact or encounter means?
I think the jury is, in this case, the jury is going to not be looking for a strict mutually exclusive distinction between those two words. Contact obviously has more contact can be, there was eye contact, and there is evidence that there was eye contact between the defendant and the victim. It could be a phone call, it could be a letter, it could be physical contact. But I think a reasonable jury, after hearing the evidence and the arguments in this case, is going to see those words as sort of different ways of looking at the violation in this case, which was the deliberate coming within whatever the proximity was. And that being the case, the prosecutor was not required to ignore other evidence that the sister was there, that the sister was yelling at the victim, particularly where the defense was accident, meaning that the Commonwealth was required to disprove that the initial coming within 100 feet, if it was feet, or yards, if it was yards, was an accident, and that having done that, the defendant was required to take reasonable steps to end the proximity. The fact that the sister is yelling at the victim is highly relevant to that, because it makes clear that the defendant knew that he was too close to the victim, and that this continued while he made eye contact with her is highly relevant to the question of whether he took reasonable steps and immediate steps to end the violation, to end the proximity.
How about this? The defense raises this, that the prosecutor argued in closing that he intentionally re-approached the complainant. Did he ever approach her? How is that supported by the evidence?
That is not 100% clear. He was behind her, I think he was behind her coming in, and she saw him. And then later, she looks up and he's right there. And I think that's sufficient to constitute.
So at trial, we don't have him leaving the store and coming back in?
I think was there evidence that he left the store? I don't think he has to leave the store.
I think that might be in the opening statement, but it's not. It doesn't come out in the evidence.
It's not clear from the evidence that he left the store, but that's not required.
Well, there's no evidence that he left the store.
No. But it wouldn't be required that he leave the store and come back in.
No, I understand that. I'm just trying to figure out what happened, but all right.
I think the argument is he should have left the store the moment that he saw that she was there also.
Yes, of course, that sounds right.
And it's fair to bring that.
But we know that he saw her once and then approached her later?
I believe so. But since there was in substance only the one theory, counsel cannot, and, you know, it's admirable for counsel to take one for the team, but I don't think counsel could have been ineffective in this case for not objecting to the sort of extraneous word contact being used when there was no evidence beyond the eye contact of, and there was no point where the Commonwealth argued or the court instructed that if the defendant...
Are we looking for a substantial risk of a miscarriage of justice?
Yes.
Or this is not the kind of structural error that per se requires, if we were to find the jury were instructed on
No.
two theories, you have a general verdict?
No, absolutely not.
Do you have a case for that?
I can reel off the cases that say if an error is not objected to. I know of
lots
case
of errors
that
where no
says-
objection results. They seated 4 jurors. You'd reverse. You
Yes.
wouldn't look
No,
at
structural-
you know, right?
Structural error exists.
Yes.
Structural error can also, I'm here to tell you, can also be waived.
Maybe.
Commonwealth v. Lavoie.
It depends on the error, but go ahead.
No, it doesn't. Structural error
Okay.
can be waived.
We can talk about this.
We can talk about that
in some case in which it's relevant.
Where there is an actual potential structural error. I know of no case that says sending a case to a jury on 2 theories, even if there had been an instruction on one theory and the evidence was not sufficient, on both theories, evidence not sufficient for one of them, that's not a structural error. I know of no case that says that, and the defendant has cited none.
Remind me, if you will, how did the judge come to rule that he was not going to permit an argument based on the third-party contact?
I'm trying to remember if the Commonwealth had requested it. The prosecutor must have requested it, because otherwise I don't know why the judge would have said, you can't argue that and I'm not going to instruct on it. She may have said, and I don't have the full transcript in front of me, I apologize. She may have said, I would like the court to instruct on third-party contact, which is what we're talking about here. And this is actually just where I was just now. There was no point at which the prosecutor argued the defendant knew he couldn't contact her directly, so he had his sister do it. That's what third-party contact is. And the judge, I think, probably appropriately ruled that that was not supported by the evidence here. We could debate that, because there was evidence that the defendant spoke to his sister before she yelled at the victim.
The judge never prohibited the Commonwealth from...
He didn't say you may not mention the sister. And in fact, the sister's behavior is highly relevant to the defense of accident. And so we were not required to pretend that it didn't exist. And I think reapproached, given that there were 2 moments when they were within sight of each other, is a reasonable inference from the evidence, and certainly
Behavior
not.
is relevant to his intent?
Sure.
How?
He saw her once, and then he saw her again and was
Well, that's clearly relevant. I'm asking about the sisters yelling.
Oh, the sister's yelling is relevant to the fact that the defendant knew that he was close to the victim and not dragging everyone away.
I see.
It's highly relevant to that. And it's not, and there was never, I think, even a whiff in the argument or the instructions that this was something where the defendant was contacting her through the sister. And so there being no error and therefore no ineffective assistance.
Do you have any hypothesis about why the model instructions say encounter?
Sorry?
Do you have any hypothesis of why the model instructions say encounter?
Well, I think because particularly where there is a distance requirement, potentially, I mean, I suppose in theory, a person could violate that order by being, if he does so deliberately, and I'm trying to think of the circumstances where this could happen. I think the crowded Walmart in Tewksbury is probably not the best setting for it, but if there's a situation where the defendant is simply within 50 feet when he's supposed to be 100 feet away, has his back to the victim the entire time, and there is no no physical contact, no eye contact, no verbal contact, if it's shown to be deliberate, it's a violation of the order. So
It's an
I think,
encounter.
and there would be no contact in that case. I mean, that would be a strange case indeed, and I don't know exactly how you would try it, but.
Who writes these model instructions?
They are approved by the courts. But there's a commission, isn't there?
By the Superior
Committee?
Court, like by the whole department?
No, district court, these
Oh,
are
district
These are the
Yeah,
district
yeah,
court
I'm sorry.
instructions, which are, they do have a sort of stamp of approval from the district court, but I also don't know what the precise mechanism for
all the
that is.
possible authors that I can think of are all judges now.
That's right.
That may well be, so. All right, then I would ask the court to affirm the judgments.
I
Thank you
see
for
no
your time.
further questions. Thank you very much. Excellent argument. Excellent argument by both of you. The case is submitted. The next case we will hear is an impounded case, John Doe, number 34413, versus Sex Offender Registry Board. And again, counsel, I'm sure you're familiar with the impoundment order, and, please adhere to it during argument.
Certainly. Good morning, Your Honors. I'm Brandon Campbell for the petitioner John Doe. A fairly straightforward argument here is that our position is that the board simply did not prove with a high degree of probability that Doe presents any cognizable risk of reoffense.
Do you know, your position is that presenting the same background risk that non-sex offenders do is the test for no cognizable risk?
So the cognizable is not located in the sex offender registry law. That comes from actually a decision of this court, and it is largely undefined. The decision where that appears defines it as simply something, it has to be something more than no risk or zero risk. And what I have done in my briefs is to point to the latest research that actually postdates the current, the last formulation of the board's regulation. And it actually, there is an objective way of defining what a cognizable risk is from a scientific standpoint. Now, reviewing sex offender registry decisions, whether it's a level 1 or a level 2, a level 2 or a level 3, high risk or moderate risk, these are difficult questions. I submit that much of the analysis, much of the review by our courts has been based on whether or not the factors have been properly applied.
Were they properly applied here?
Properly applied, and then,
Were they properly applied here?
no.
Why not?
I think, well, yes and no. I think that there needed to be more than just a rote application of the usual factors on facts that are this different. But normally, questions of whether it's a 2 or a 3 are largely upheld if the regulations are properly applied. But in this case, when you're looking at what a cognizable risk is, there is a objective scientific criteria that makes sense to apply as to
So
whether
that wasn't,
or not.
I mean, you didn't, that was not, Doe did not offer that to the board and say, your regulations are off because here's this new study that's not incorporated. Your argument is that the board, the hearing examiner, was required to say, my regulations that I have here that I'm supposed to apply are wrong.
I put it, I don't say that they are wrong.
I've done independent research.
I think that they are incomplete under the circumstances of this case. And there have been a number of cases with unusual petitioners that have resulted in reversals. Female offenders, very old offenders, very young offenders. These are all classes of cases where the petitioners fell outside of the standard analysis.
So when you argued to the hearing examiner, not a level 1, but relief from the obligation to register, what argument did you put forward? Presumably it wasn't these articles, so did you just say, look, 25 years, old age, no sex offenses, if not him whom? Like, what did you say exactly?
I was not the
What did
attorney
his
at the
counsel
hearing
say,
level.
or- yeah.
The prior counsel largely argued, as you say, this is a long time. There hasn't been any other sex offenses. You know, it's
I mean,
25 years.
I'm somewhat moved by the articles. You know what I mean? But I do think, it's a question in a way of, were they really presented in the, in a way that, because of course the examiner allegedly has to take them into account if you present them. I think that's factor maybe 30 or something like that. I don't remember. But I interrupted you, Judge.
So the articles weren't before him, right?
Correct.
Continued contact with the criminal justice system, that's a factor, right?
Yes.
And we have that here?
Yes.
So to say, hey, it was just 25 years ago and there's been nothing, or however long it was, I might not have been 25 years, but essentially, that wouldn't be accurate, right? I mean,
Well-
that's why I ask, did anybody wrongfully apply the factors?
Well, the analysis, however, is not whether or not Doe should be on a domestic violence registry or a bad husband registry. We're dealing with the sex offender registry here. And from the 29 decision from, I don't know, it was Judge Gantz, the analysis is supposed to focus around the original offense and how the petitioner might reoffend in a like way in the future. And all of these things, all of his contacts that postdate this sex offense are entirely different from the underlying sex offense. There was no violence at all in the single solitary sex offense from 1994. So the analysis should start there. So the question is, what bearing do these...
But again, are you agreeing with the premise here that if you read the regs, there is allegedly bearing, but you're saying as a matter of fact, there isn't? Is that what you're saying?
I'm saying that the regs are... the best way I can put it is they're incomplete on this type of scenario where we have somebody who falls really outside of the regs. The regs stop at 10 years for time in the community. We're at 25.
Okay, but what I'm saying, but the regs don't say more than 10 years, you can't, someone offense-free for more than 10 years can't be designated a sex offender.
Right, so
I'm just trying to figure out, because I think what I'm struggling with, at least, and it sort of relates to Justice Desmond's question. I'd be willing to posit, although I'll ask Mr. Shania about this, I'm willing to posit that someone who commits a sex crime 25 years ago, I don't know how we want to characterize this kind of sex with a 14-year-old, violent, not violent power relationship, but without even characterizing it. If that's the offense, and for 25 years the person not only doesn't commit any more sex offenses, they don't commit any offense of any kind, then okay, maybe we look at that and we say there's no cognizable risk. He hasn't in 25 years, he's been in the community. What are we talking about here? So, wrap it up. But here we have these incidents, I don't remember how many were credited by the hearing examiner. There are 4 that are alleged incidences of criminal conduct subsequent to this, the latest, I think, 10 years ago. And I'm just trying to figure out, I take it your position is, that's exact, for purposes of this, that's the same as no subsequent contact with the criminal justice system.
The board didn't present anything that said that there's a high degree of probability that Doe still presents a cognizable risk.
So it still presents
A cognizable risk. And if you look at the Hansen research, time in the community far out.
No, I see that, but that Hansen research wasn't before the board. At least the current Hansen research wasn't before the board. That is correct. I mean, we do get these cases. It's not the first case I've seen where someone has said because of time alone. It is the first one where I've seen this article, though.
And factor 10 is a risk elevating factor, isn't that right?
Yes.
Okay. And factor 10 reaches all the way back to even if he was a juvenile, doesn't it?
It applies differently.
Ongoing criminal behavior weighs heavily in the application of factor 10. Analysis under this factor shall include the consideration of the number and type of criminal charges committed as a juvenile.
Okay.
I mean, I don't know. It seems to me that treating the criminal charges as a juvenile of a 62-year-old gets to be a bit much. But of course, many of the offenders are not 62 years old. Right, I mean, if all we had here was a violent crime when he was, 17, and this event, and then nothing since, that seems almost the same to me. It's just no offense. But there are these repeated offenses, and I understand what you're saying, that they don't overwhelm the predictive value or alter the predictive value of the offense-free time, and I suppose the old age.
My point is it's not sufficient for the board this amount of time when somebody is this old to do the same type of analysis. What if it was 35? What if it was 45? What if it was 50 years? We're just going to do the same thing, and we're not going to hold them to proving that these other factors that they're hanging their hat on outpace the time in the community. They don't have any structure here for saying that he's still a risk. And frankly, Your Honors, I don't think that there's any evidence out there that supports their position. No credible expert or study would find any risk in this. You don't have to take my word for it, but I don't see that the board has introduced anything that says that in these unusual circumstances that the usual analysis should just...
When was this hearing held?
About 2020, March 2020, I believe.
Is he eligible now for 3 years for a new petition?
He is.
And is the standard the same? There's no deference given to what it used to be? Or is it a change of, I mean, he has to indicate a change, and I guess he's older, so that's maybe a change.
There has been no update of the regulations.
But you could present in a new petition, if this were not reversed, you could present these articles for actual consideration.
That is correct, Your Honor.
Has that begun, or does that wait until this appeal is done? I mean, I guess it's his decision when to file a petition.
I believe the regulations state that while there is an active appeal, he cannot petition for reclassification.
Okay.
I'd point out in the, there was a similar case. It was a unpublished decision by this court. I believe Justice Massing was on that panel.
He was.
It was Doe 523671. The petitioner had been at liberty for 23 years. He was 65.
I mean, that was the case that Justice Rubin was describing a little while ago. That's the case where he commits one offense, by the way, of which the board has no evidence, and then has a completely clean record.
Well, the offenses involved two prepubescent children and occurred over a 4 to 5 year period. So it was much more serious sex offending behavior. So I think it's inconsistent for someone to get relief in that situation and not to get relief in this type of situation.
I mean, but he had completely cleaned up his act after that.
Yes.
There was no, he didn't have any 209A orders, which are, there's all these crimes, though they're not sex crimes, they are on, they're in the domestic area.
But the point of looking at non-sexual violent crimes is to see if they actually are a predictor of future sexual reoffending. And I argue that with this amount of time that has gone by, it's clear that it doesn't causally relate to his offending behavior. It doesn't show any propensity on his part to reoffend sexually.
I understand, but just because you say it so doesn't make it so, and the evidence that you're relying on wasn't before the court.
Well, this part actually was his time in the community, and his, is what it is. And despite his other issues with the criminal justice system, it has not been predictive of his propensity to reoffend, and we have 25 years of proof of that. I see my time is almost up. If there are not any other questions, I will rest on my briefs.
Thank you very much. Excellent argument.
Thank you.
We will hear now from Attorney Shanai.
If it pleases the court, Your Honors, David Shanai for the board. I want to start by saying that we got our first snow flurries in Williamstown yesterday, so winter is coming at some point. Looking at this case objectively, it really is the continued violent behavior that gives the cognizable risk in this case. And ever since, I think it was about 2 or 3 months ago, I was in front of Justice Rubin, and you raised the issue of if someone hasn't committed anything in that period of time, over a long period of time, how can we say that he still poses a risk and danger? And I've thought about that. I've been thinking that through. And I think what you're looking for, and in this case the hearing examiner has proof, at least by the board's factoring, that this individual has got some serious issues. I don't know, and I think after one of his continues out of finding when he shoulder shoved the VA female worker, he was required to do mental health counseling. I think that there were some red flags that made the hearing examiner, I think, properly determine that there's still a cognizable risk here, at least 3 years ago when he wrote.
Does it matter that his sex crime wasn't violent?
I don't think that's the issue. The issue is the things you're looking for is antisocial behaviors, lawlessness, and that's what Factor 10 brings into play here. And then Factor 11, the violent nature of it, shows that he has no regard for the safety of others, which makes him dangerous. What's interesting is the 2017 article by Dr. Hansen, specifically said, although non-sexual violence, in his opinion, doesn't toll the offense-free time, it's still an indicator of risk to reoffend. So, and again, one of the things that the desistants...
I thought he said it didn't affect the calculation of level of risk to reoffend. Am I mistaken?
My reading of it was that it doesn't toll the offense-free time, but it still is an indicator of risk. Oh. Because Dr. Hansen is saying that to really achieve desistance, the common thread is that the individuals had adopted pro-social lifestyles. And the board's position today is that the evidence isn't showing that this individual has completely grasped the idea of embracing a pro-social lifestyle. And I think that's really why the Factor 10 and 11 applies in this matter. Now, these level...
When you say cognizable risk, do you mean no risk higher than background risk?
I think it's a little bit higher than background risk. I think the hearing examiner's got to be able to point to something that says this is a red flag. And in this case...
So if you could say, I was surprised to see this, it says the background risk for committing sex offenses is something like 1% annually or something? I was just surprised that it was that high.
You know,
And all I'm asking is if, whatever the number is, if you can figure out that this petitioner has that same risk, 1% or whatever the background risk is, that's no cognizable risk because it's nothing different from anyone sitting in the world.
but I don't think the board's factors are designed to go by percentages.
I'm aware you don't
As you
think
and I have gone
that.
back and forth on this many times.
I don't really understand how you can do this without percentages,
Well,
but
because,
perhaps one day I'll write something about that. I think some others have.
Yeah, well, don't do it on one of my cases.
They're all your cases. All right.
Well, I'm hoping that I didn't argue 52671. I can't remember because they all blend together, but no, seriously, the board's factors are designed, and again, these desistance studies aren't saying that every single sex offender who reaches a certain time and offense-free time and age is automatically in that 2%. It's saying that the general population is, and that there are individuals, and there are always going to be individuals who may be outside of that range, because again, Dr. Hansen's talking about pro-social lifestyles as one of the factors. What the board's regulations are trying to find are those outliers.
All right, so the outlier in the case that you were discussing with Judge Massing, this case where the person hadn't offended in a long time and had no other record. Is that, I mean, you're entitled to your opinion, is that correctly decided and that's a no cognizable risk case? Or actually it's incorrectly decided?
This is how I'll
Which,
answer.
of course, was the board's position and argument in that case.
This is how I'll answer. First of all, I didn't lose any sleep about the decision, but more importantly, we're going to be getting now, they're coming through, after the ruling came down that every 3 years, offenders have a right to a reclassification. And this is a case where it went from a 3 to a 1. We're getting a lot of 1 decisions now.
It actually went from a 2 to a 1.
Yeah,
Actually,
no, I think it was a 3. We recommended a 2 for the reclass, and it was dropped to 1, is my memory of it.
Yeah, no,
But you
no.
could be right. But we're going to be,
On that point, I'm sorry, was it 2 to 1? It's 2 to 1, right? Not 3 to 1.
I thought he was a 3 in 2002, and that we recommended in October of 2019 that he be a 2 on the reclassification, and that the hearing examiner made him a 1, is my memory of it. But again, if it could be wrong, it might have been a 2 to a 1, but I'm pretty sure it was a 3, recommended a 2.
I think I think in the 2002 decision, there was a typo at the beginning, but at the end, it pretty clearly says level 2. It's a record 30 and 516.
But we're going to be getting a lot of these level 1 cases, and truthfully, they're going to be tough decisions, whether or not someone still poses a cognizable risk. For instance, I've seen a couple already where I really believe that they didn't, but the hearing examiner still made them a 1, and those are in the Superior Court right now. And I've seen others where I thought it was well-founded. And I think this case, because of the ongoing...
You required to defend the hearing examiner's decisions once
Yes.
they're made? Okay.
Yes.
Has a hearing examiner ever relieved somebody in a case where the statute doesn't allow it, like this one?
Yes. I've been seeing quite a few that they have relieved. So it's not like and the problem is those aren't the cases that are appealed, but I would say right now, I'm seeing at least 10 to 15% of these long-time events that happened long ago. I'm seeing probably about 10% of them are being dismissed or ordered not to have to register.
What's the youngest petitioner that you've seen, if you can remember?
I would say it would have to be someone, I think the youngest I saw was probably in their late 50s, early 60s.
Oh, all right.
And again, a lot of it has to do with the type of sex offense, how long ago it was, and what they've done in the interim. There's been many, many of them who have done really well in life since their sex offending behaviors, and that's taken into account. And again, we're seeing much more of these cases being ordered not to have to register than I'd ever seen in the past.
And are you amending the regs to take account of these new studies? And when will that be done?
Actually, the last I heard, the regs had gone to the Department of Public Safety to be reviewed, the updated regs. My assumption is that these new studies are in there. I haven't seen the new regs yet, so I can't guarantee that. But, you know, when the new regulations come out, we'll have a whole new arena of argument to go through as we get used to the new regulations.
But I mean, here the last, you know, the last violent unrelated to sexual act is 2014. And that was 6 years ago at the time of the hearing, and now it's 9.5 years ago. I mean, like, is there a basis in the regulation for deciding when something becomes far enough back?
Again, I think that you have to look at more of a qualitative analysis in the sense that, say, in the next reclassification, which he'll have a right to, he'll be beyond the 10 years. And that'll have to be taken into account by the hearing examiner, that his last non-sexually violent offense happened over 10 years prior to
That's 10 years is in the regs.
Right, and then after that,
10
when it
years
gets
is
to
in the reg not for the index offense or for a sexual offense, but also for non-sexual criminal contact, contact with the criminal justice system?
Correct, but specifically for offense-free time, it has to be either a new sex offense or a non-sexual violent offense. It's not just a criminal offense in general. For the Factor 29 situation. So the further out he gets from his behaviors, because that's going to indicate that he somehow is getting closer or has adopted a pro-social lifestyle. I mean, he had a lot of positives in his favor. It's just that it appears that he has some serious issues, emotional issues, that seem to revolve around women, and again...
The hearing examiner doesn't say that. I mean, I noticed that too, and I thought, well, one of them allegedly involves, I think it was his wife at the time, and demanding sex. That's the oldest one. And one of them involves a kind of stalking type behavior that, at least I've seen real life cases that seem, I'm not saying his situation is intertwined with sexual violence as well, but that's just not what the hearing examiner finds about these, right? It's not, if it were tied tightly to sexual misconduct, then, you know, then we wouldn't be talking about 25 years with no hint of sexual criminal or, you know, whatever.
Right, I think the hearing examiner focused more on the fact that they were violent offenses.
Yeah.
I mean, I was surprised the hearing examiner didn't apply Factor 15, which is hostility towards women, because he does have a history of that. But the hearing examiner didn't go that way. The hearing examiner really just focused on the violent.
But you all asked.
What?
You all asked him to consider that factor.
Actually, I did the hearing. I generally don't ask hearing examiners to focus on, say, a certain factor. I assume that they are the fact finders, and if they feel it applies, they will apply.
So you personally can do a hearing, lose in the sense that you said 3 and he says 1 or whatever, and then you have to defend his decision even though it's not the one you wanted?
Essentially, I've done through the Superior Court, then to this court, and then I'll have the case, I'm sure, on the reclassification hearing, and I'll begin it all again.
Just all seems very odd to me, but...
Yeah.
You were saying that
It's
there's
a
been
living.
cases that you think, well, you said you didn't lose any sleep over a certain ruling on a particular case when it didn't cut your way. But then you were getting ready to say, but as to this case, and what was your thought? What were you getting?
My thought on this case, again, is that the difference between the two cases is that we still have evidence that he recently, or 6 years prior, was still continuing a violent criminal behavior. And those are red flags, and I think that makes this case a little different than 52671. But I'll be truthful with you, I don't lose any sleep about any of the decisions on any of my cases because, we're looking for fairness here. And if the appeals court feels that a decision's unfair, then I think it's incumbent on the court to overturn that. Just like, when I go into a hearing, I'm looking for a fair result. I'm not looking to prosecute the person. I'm trying to put all the evidence in, let the other side put all their evidence in, and hopefully the hearing examiner will make a fair decision. Because again, the board isn't prosecuting. The board is trying to get the right number to protect society, but also balance the rights of the individuals involved. At least that's my opinion of the process. And I see I'm already past my time or close to it.
You got a minute if you want it.
No, I'm always willing to sit down when it's time.
Okay, I see no further questions. Thank you very much, both of you. Very interesting case.
Thank you, Your Honor.
Very well argued on both sides. The case is submitted. We will take our traditional mid-morning break of 10 to 15 minutes before the final case. Court is in recess.
For the session, please be seated.
Welcome back. We are indeed back in session. We will be hearing next, if I can find the proper piece of paper, the last case of the morning, which is also partially impounded. But I gather the name of the defendant is not impounded, is that right?
That's correct, Judge.
So this is number 22-1043, Commonwealth versus Cordeiro, and we will hear first from Attorney Cunha.
Thank you. If Your Honors, please, John Henry Cunha on behalf of Karen Cordeiro. I'd like to start by saying that in my 46 years at the bar, this is a unique case, understanding the real meaning of unique, the only one I've ever seen. And that includes the last 40 years that I've been on the murder list.
Can you pull the microphone up toward you a little? You're
Yes.
just a little taller than our prior guests.
Okay, let me see
Thank
if
you.
I can.
That's fine. I'm sure that'll,
I'll,
yeah, that's great.
I'll try to be cognizant of it, Judge. I'd like first to just run through the timeline, which is that Ms. Cordeiro was arrested on February 4th, 2005. She was charged with first-degree murder at that time. The case was tried, and a second-degree conviction was entered in January of 2007. I was appointed at that point as the appellate lawyer, and after filing a motion for that she be examined for competency, well, actually, strike that. The first thing that happened is that the government filed a notice of appeal of the grant of the motion for new trial, and while that that notice of appeal and the appeal, therefore, was still pending, bail was set pre-Brangden in the amount of $250,000 cash to $2.5 million surety.
Just a quick question. So was criminal responsibility or competence raised at all at the first trial?
It was not. In fact, that was one of the factors that Judge Garsh focused on when she granted a new trial. Her findings were she may not have been competent during trial. It had been the trial counsel, who otherwise did a fine job, was aware of the competency issues but had not raised them with the court. So there was a potential for ineffective assistance of counsel. But I also note that in passing, in her opinion, which is in the record appendix, she also said that there were questions about whether she was not criminally responsible during the event. And she didn't need to make any findings on that, and so there was no finding of that.
Wasn't she evaluated just before trial? Didn't they actually bring somebody
I
up
think
to
it was right after arrest.
first 2 days?
I think it was after arrest, Judge. When she spoke to the police right after the event, and she said, amongst other things, that they asked her if she had any mental health problems, and she said she didn't know because there were times when she, I'm sorry, Judge, I don't have the specific words, but basically she said where she's not sure what she did, or she's not sure what she's doing, or there was something that indicated that there was a potential for mental health issues. And she was evaluated at that point. She was sent for evaluation to the state hospital in Taunton, and the report came back from the examiner, who was the same examiner who testified at the motion for new trial, well, it would be, at that point, 6 years later, and said that, in his opinion, she was competent. So,
Can I bring us up to date a little more, because
Please.
time is short?
yep.
In order to remain committed in Worcester, I gather she has to be a danger to herself or others. Is that correct?
I believe that's correct, Judge. She is civilly committed.
When does that expire?
It's a year-to-year. It's a year-to-year determination.
But if they want to send her to outside treatment center or group home or whatever it is, presumably they've concluded she's no longer a danger to herself or others. Is that right?
That is right.
So where is she now?
She's at Worcester.
Despite not being a danger to herself or others, and that's because the court order continues in place?
I think, Judge, here we're getting into practicalities. And one of the things that has happened over the years is that Ms. Cordeiro is represented by counsel, other counsel for the civil commitment proceedings. I think CPCS has a unit for that. And every year they waive challenge to the petition. So there's never, when there's a waiver of the challenge, then the order is just continued for a year.
If she's put back in jail,
it's going to be a disaster.
I'm sure that's right, but if she's put back in jail, what's the point? When can she be tried? I read something in this record that says she will never be competent.
That is a possibility.
Are you familiar with?
I am, Judge.
GLC 123-6F?
I am, Judge.
And under 6F, a person who will never be competent, if they've served sufficient time to be eligible for parole if they had been convicted, the criminal charges have to be dismissed.
Yes, Judge.
So why are we talking about bail? What are we talking about at all? Why?
Well, that may be the next step, Judge.
Wait. Why is it the next step? On the day she was eligible for parole, isn't that the first step?
Well, perhaps, Judge, but what we were being told by her caregivers was that they wanted to get her into this.
If the criminal charges are dismissed, she can do anything she wants.
Well, she still would be subject to at least the potential for civil commitment.
To what?
She would at least be subject.
Yes, but you've said that she is no longer a danger to herself or others.
Now, that would be.
All right, so she won't be civilly committed, if that's true. I don't know if it is, but there's an opinion here, and I'll ask the Commonwealth what their view about all this is. But if she can't be civilly committed, which I gather is why we're talking about bail, she's no longer eligible to stay in Worcester, if that's even a good idea, which I have no idea. I'm just trying to figure out why we're talking about bail. The Commonwealth is not allowed to hold someone for their whole life who's incompetent to stand trial.
And that's probably why the government has recently filed a motion seeking independent review of her competency. There are reasons why we have. I'm aware of the statute. Perhaps we should have filed a motion to dismiss, but we did not. Okay. I don't know what else to say.
And I'm not, I'm not telling anyone how to do their job, but I was looking at this because I was thinking, well, all right, so they put her in jail and she can't make bail. She just sits there forever? Like, what if she's incompetent? And I was surprised to find there's this statute about people who are indefinitely incompetent. But okay, we've got the bail question here. The judge has to consider, I gather, the less restrictive alternatives to unaffordable bail.
Yes, I think Brangen refers to them as
alternative. And what have you proposed?
We proposed that she, in conjunction with her caregivers, we proposed that she go to a community-based facility, which is supervised 24 hours a day, 7 days a week, it's a facility for mental health patients. In other words, it is a facility. It's
privately owned, though? It's not a government?
I think they're licensed through the Commonwealth, is what it is.
Locked facility?
Pardon me, Judge?
A locked facility?
Yeah,
it is not.
It's not locked.
No.
And is it based on a voluntary surrender?
Pardon me, Judge?
Is it based on a voluntary surrender?
At this point, she can, pursuant to the civil commitment order, she can be, the hospital can send her to the community-based facility. So it is considered to be a facility.
So she's still civilly committed, but there's nothing keeping her from walking away. That's not much of a commitment.
Well, Judge,
usually if you're civilly committed, you're put someplace locked, right?
Yeah, her caregivers are saying that that she's a danger to herself or others. And there is evidence for that in the record.
Well, then she can't be civilly committed. It's one or the other, right?
Yeah, I'm not in a position to address fully the civil commitment issue because I'm not involved in the case. But I do know it's year to year, and I do, and
Doesn't this have something to do with what the alternatives are? What alternatives did you propose for making sure that she doesn't fail to show up for trial?
We did not, Judge, but I frankly assumed that a bracelet would be ordered.
But how come not, how come you didn't propose it this time? Didn't you propose the bracelet the first time through?
I actually didn't, I don't remember, Judge, but I could very well have. If I didn't, it was probably an oversight. I assumed, quite frankly, that a bracelet would be ordered.
And what's the record support for she's not a danger to the community?
Well, for one, she went on a number of visits to the community with mental DMH, or excuse me, Worcester Recovery Center personnel. She went on a number of, they were supervised visits, but she went into the community a number of times. I think what happened is that when that is now no longer available to her, I believe what happened is that the hospital recognized because of her bail status that she shouldn't be doing that. So, but she went on a number of them.
Your brief says that she's no longer a risk to herself or others, and you cite something in the impounded appendix, some kind of evaluation.
That's the IFTRA, Judge. I think it's IFTRA, if I'm not mistaken.
What is that?
That is a diagnostic examination that's performed by somebody who has to be certified to do those examinations, and basically it's a comprehensive evaluation.
But is it ordered by the court? Is it part of the civil commitment process?
Part
is
of
it
the
voluntary?
it's part of the Worcester Hospital.
It's treatment.
It's treatment.
I
yeah.
see. And if you didn't present to the judge in the motion for release on personal recognizance any less restrictive alternative than bail, how could the judge?
I think that 24/7 is a less restrictive alternative.
Unlocked.
Unlocked, but nevertheless, there's somebody there the whole time, and I believe that the record is clear, and it's in the record appendix that if there were issues, they would be immediately reported.
To Worcester?
To Worcester, yes.
So this would be a referral from Worcester where she is committed.
Correct.
Oh, but we are back at this problem. She has to remain civilly committed for Worcester to have anything to do with this, right?
I think that is not true. I think that she can go there as a civilly committed person. However,
well, you or I could probably go there if we'll pay for it.
She still would be a DMH. There's a distinction between a Worcester and DMH. Even though Worcester is a DMH facility, she would be able, under the Department of Mental Health, to stay at the community-based facility even if she were not civilly committed.
Have you met with her in person?
Many times. I think that one of the things the record shows is that this all began after the government withdrew its notice of appeal. The case was put on the trial list, and I went to see her in the lockup before trial that day, and she thought I was Mr. Gagney. And I asked that she be examined for competency, and she's been in the hospital ever since.
I'm sorry to keep harping on this, but so if she goes to this step down thing, again, is it like, can she just decide on her own? I mean, it's 24/7. Can she decide, I don't want to be here anymore? And will she be there under a court order, or will she be there voluntarily?
Well, I mean, if it's a condition of bail that she remain, then she is under a court order. Absolutely.
And so if she were to walk away, she wouldn't be prevented from walking away. Somebody would just be notified that, hey, she just walked away.
Right, and not only would the Worcester be notified, but if it was a condition of bail, the court would be notified.
Do we know if anyone has looked into whether there might be a locked facility somewhere that isn't Worcester, but that might provide this level of care?
There isn't. Worcester, it's either Worcester for locked, it's either Worcester I mean, there may be other state
Every
hospitals, but as well.
Psychiatric, I'm sure there's a locked part of McLean, I'm sure, right, I think.
No, I don't think so, Judge. I think that it's, now maybe.
Not for purposes of incarceration, but for purposes of protecting themselves and others from possibly dangerous people.
I think that the answer to that is twofold. One of which is that after treating her for many years, and she has stabilized, they don't feel that she's a danger to herself or others. So that's not a clinically appropriate recommendation. And the second is that, I believe, for instance, some of the other state hospitals, Taunton, et cetera, that they also have locked wards, but they're no different from Worcester. There's no facility that is different in kind from Worcester that is locked.
Yeah, one more question.
Sure, please.
Among things that, the idea of financial ability to pay.
Yes, sir.
I read the transcript of the hearing. It's not really mentioned there. Has she been declared indigent?
I was appointed. She had appointed counsel at trial. I'm appointed counsel.
Okay, thanks.
And the IFTRA report, where is that in the appendix?
It's in the, I believe it's in the impounded record appendix. Perhaps my colleague can give a better answer than I can off the top of my head. I'd like to keep going, but I know I'm over my time.
No, your time is up.
Yeah.
You can keep going only if I see other questions, and I don't think I do. Thank you very much. We have your argument. Very interesting case.
Could I just give you one quote from Walsh that I'd ask you to consider? It's very quick.
I don't know why I'm saying okay, but okay.
Thank you, Judge.
Is it in your brief?
It's Walsh, 485 Mass, Commonwealth versus Walsh, 485 Mass, 582. And the SJC says, when a judge sets a bail that a defendant cannot afford to post, the judge must do more than articulate the animating rationale for that determination and indicate in a general way that he or she has considered the relevant factors. And I think that that's exactly what happened in this case.
Okay, thank you. I think we're actually familiar with that quote. We will hear now from Attorney Gagne.
Yes, good morning, Your Honors. May it please the Court, Stephen Gagne on behalf of the Commonwealth. I'm a Special Assistant DA for the Bristol District in this case. I've represented the Commonwealth since the morning of Courtney Sau's murder in 2005, and I would like to acknowledge that Courtney's mother, Karen, is here today in court with me. Your Honors, the standard of review at this stage is whether or not Judge Yesayan or Chief Justice Green, as the single justice, abused their discretion or committed an error of law in denying the motion for release on personal recognizance. And I would like to emphasize, as Your Honors have noted this morning, this was a release on personal recognizance with no alternative proposal for some lower bail or conditions of release. It was all or nothing. The defendant went all in on personal recognizance. And specifically, in the transcript of the hearing before Judge Yesayan, at page 26, which is at our supplemental record appendix, page 83, Attorney Cunha said to the judge, "And Judge, in terms of conditions of release, that's up to you. I'm not suggesting anything." So that's what the judge had before him. And as far as this risk assessment report, Your Honor, Judge Desmond, you asked about that. I don't believe the report itself is in the record appendix, nor was it provided to Judge Yesayan. It was a representation by counsel that one had been done.
Well, we have something in the impounded appendix at pages 23 and 24. I don't know if you have it available to you here, but I thought there was something. Hold on. Of course, it's impounded, so there's a limited amount I can say about it. Hold on, what's it called? It's many pages long. Oh, this is a competency to stand trial evaluation.
Correct. Yes, that's an evaluation that was done, I believe, at the defendant's request, a defense-retained expert in 2021, in which essentially that report boils down to a finding that the defendant finds coming to court too stressful, and that she essentially decompensates due to the stress of coming to court.
Are you familiar with 16F?
I am very much.
So is this not a 16F case? I don't understand why we're talking about bail.
I have a feeling that the next time, if there is a next time before this court in this case, it will be on one party's appeal from a 16F motion.
Tell me why it doesn't, like why you would contest it. What is missing here?
What is contested, Your Honor, and what we are actively currently contesting in the Superior Court, as Attorney Cunha represented, is that we have filed a motion for a renewed and independent competency examination of the defendant.
So you do not agree that it will, I mean, I guess you're saying you don't know, but you do not agree that she will never be, or not in the foreseeable future, whatever the words are, competent?
We contest that.
I see.
And, Your Honor, I think what's unique about this case is that for about 9.5 years, there was essentially an unspoken stalemate here where the defendant was being found incompetent. The defense wasn't challenging the bail. So she was in custody.
Sure.
But now, apparently, when they want to release her to this residential facility, now suddenly the bail is standing in the way and it's being challenged.
Well, this is a question for clinicians, though, or something, right? I mean, if she's competent to stand trial, then she doesn't go anywhere. She has a trial.
Correct. And we maintain a strong interest in that.
Sure, of course.
And, Your Honor, as you noted earlier, under 123.16c, which is the civil commitments she's been under, every year the hospital, Worcester Recovery Center, has been filing these petitions. And in the defendant's record appendix, they have the one from 2021, which was the last time she was up for recommitment prior to this bail motion being filed. And every single time she's been recommitted, the court has found that failure to retain her in a facility would create a likelihood of serious harm. So they are holding her because that...
Is there anything in the record appendix from Worcester with this recommendation that she go to a step-down facility? I don't see how those can how they can file a paper saying she's a risk of harm to herself and others, and also saying, but let her out of the locked facility.
It's flatly contradictory, and Judge Yasayan put his thumb on that issue at pages 25 and 26 of the transcript of the hearing. He questioned the defense about this apparent contradiction between what the doctors are saying in their affidavits, on the one hand, that she's stabilized enough that she's ready to go to a non-locked community residential facility, versus the 16C petitions, which is a judicial order saying she still presents a danger. So Judge Yasayan spotted that issue, and he factored in that into the mix when he denied the motion for personal recognizance. I think when Your Honors look not only at the one-page decision by Judge Yasayan, but also at the transcript of the hearing that he conducted where he did ask probing questions, that he did exactly what we would expect a judge to do on a bail motion.
Well, the order should contain probably the you know what I mean, an assessment of the factors, I would think.
I would, if I could just answer that question, Your Honor. I think when you read his decision, I counted 5 factors. 1, the defendant's mental health. Secondly, the strength of the Commonwealth's case. The 3rd, the nature and circumstances of this case, which he described as a brutal, violent attack. 4th, the potential penalty the defendant faces if convicted. And 5th, the lack of any competency restoration efforts.
Isn't the potential penalty eligibility for parole?
Well, it depends how you look at it. On the bottom end or the top end, the potential penalty is life in prison.
No, I understand that.
Eligibility for parole, yes, she would be eligible.
She will be out, like if you convict her tomorrow, she can try to get parole the next day.
That is true. She would be eligible for parole. Not to say there's obviously no guarantees with how that goes.
No, of course.
So, Your Honor, although...
But I'm just trying to figure out how serious the threat of, in terms of bail, the threat of the sanction is when it no longer, when it's not even a sure thing. I mean, obviously parole is also not a sure thing.
Well, that leads to another point, which is the defense claiming that Judge Usain committed an error of law when he supposedly denied the motion just based upon the type of crime and the potential penalty, which, as I just noted, I count at least 5 factors on the face of his order, but when you also read the transcript of the hearing, you do see him considering other factors and asking probing questions about what the defense was proposing here in lieu of bail. The defense says today that they assumed that there would be a GPS ordered by the judge. That was never proposed. It was never asked for.
Did the Commonwealth suggest that if he were going to grant it, they wanted something other than personal recognizance, or it was just a flat deny this?
Our argument was that obviously the court could deny the motion flat out, but if not, I proposed that there needed to be additional hearings at which we could really probe whether or not competency restoration efforts had been attempted, the contours of this residential facility, and what other conditions may be appropriate. We never got to stage 2.
I see.
So that is something that
But I interrupted Judge
I just
Desmond.
have a quick question. I read the defense papers to suggest that her present bail status is impeding her from getting treatment. Is that accurate?
Well, I wouldn't say it's impeding her from getting treatment. She's been getting treatment, and in fact, the affidavits say that her time at the Worcester Recovery Center has stabilized her mental health condition. Apparently, some of her providers at the hospital think that this may be beneficial for her, or they perceive this as the next stage of her treatment, but that's not to say that the bail is having a detrimental effect on her mental health.
Well, except that she can't go to the treatment facility because the alternative to Worcester for her right now is jail with unaffordable bail.
Well, the alternative is if she's not suitable, if she's not supposed to be at the Worcester Recovery Center, then there shouldn't be these recurring 16C petitions that she's been assenting to all along. And I can represent to the court her current commitment expires on or about 2 weeks from yesterday, November 15th. The hospital tells me, as the DA has the right to be notified, they intend to file for recommitment under 16C.
Let me ask you this, and I don't know, it's not exactly mentioned anywhere. If holding someone on bail will cause a severe mental disturbance of some kind, they're mentally ill, it's very fragile, and if you hold them on bail, they're going to, everyone uses these words, decompensate. I'm sure that means something technical that I don't understand, but whatever. They are going to become floridly mentally ill again and wind up for 5 more years in the Worcester Center or some other mental hospital. Is there any way for that to be taken account of in the bail calculus? Or the bail calculus is not, like that's not part of it, because the point of it is just to have her present for trial.
No, I understand your question. I think that if this case had been in a different procedural posture when Judge Usain considered it, for example, if the motion were the defendant no longer is suitable for 16C commitment, the hospital intends to discharge her on X date, but Your Honor, when that happens, if she goes to the jail, X, Y, and Z will happen. I think that would certainly be a relevant factor for the judge to take into account. But that was not the posture of this case when Judge Usain was asked to release her on personal recognizance. So yes, if the alternative is she's discharged from Worcester, she goes back to the Bristol County House of Correction held solely on bail, then that's a different bail motion. And I think that's a different mixture the court has to look at. But that's not this motion. So that may be an issue for another day. If there's a renewed motion for bail in the Superior Court, if circumstances change, if there's a 16F motion to dismiss for lack of competency, that again is a different issue. But here, we're simply looking at, did Judge Usain abuse his discretion or commit some legal error, which I'd maintain he did not.
Do you know anything about a civilly committed prisoner being allowed as part of that civil commitment to be in an outside facility? Like, does the law provide for that, right? Because I take it what her lawyers are saying is she'll still be somehow committed to Worcester, but undertaking but they're going to refer her, like within the rubric of their treatment, to this place. Can that happen? Does that happen? I mean, you may not know. I don't know anything about this.
That's a bit outside of my wheelhouse, but I think that if, as Attorney Cunha mentioned, if the judge in the criminal case set orders or conditions of release that she go to a certain facility, whether it be locked or unlocked, under DMH's umbrella or not, then there at least is the force of law sort of putting some strictures there.
If the judge is allowed to do that, that's what I'm asking.
Is a judge...
Can the judge say, you'll go to an unlocked facility? Or is the only place that you can send a prisoner Worcester?
If she's a prisoner, I'm not so sure. I'm not so sure what the options are.
Because she is, right?
She is, yes. She is currently considered a prisoner.
Yeah.
So...
I wanted to go back to something you said a minute ago. You said that at the hearing that the defendant's position was not. I want to go to this step-down facility, and because I can't accomplish any more at Worcester. But if the judge says, if you don't intervene, then I'm going to go back to jail, and that doesn't work. I mean, isn't that exactly what he argued? I think you said something that wasn't the case here?
No, that wasn't the case, and her return to Bristol House of Correction was not imminent because she was still halfway through her current 16C commitment at that time with no indications that Worcester intended to discharge her or withdraw its next 16C petition. So Judge Yusayan was not faced with the prospect of either maintain the bail or she's going back to the jail.
On the very beginning of the argument, he says that I've got Exhibit A, which is Dr. Hutton-Back, Exhibit B, which is Mr. Whalen. They make it very clear she's ready for this. I mean, that's how they present it, isn't it?
Oh, sure. Their argument was that the hospital is recommending that she go to the residential facility. Yes, I didn't mean to misstate that. But the prospect of her going back to the jail was not before the judge. That was not ripe at that time because she was still under 16C commitment, and she still is to this day, and they intend to refile. So for all intents and purposes, as far as her 16C commitment, she's not going anywhere anytime soon. So this prospect of the cash bail kicking in and that forcing her remand to Bristol, that's just not, that hasn't been a realistic scenario when this motion was filed nor since.
If you want her to become competent so you can try her, isn't it also in your interest to go with this program?
I think it's in our interest to pursue the motion that we've recently filed, and I recognize this isn't in the record, so I apologize for bringing it up, but I could supplement the record either through a 16L letter, but we...
It's not really 16L, so...
A motion to expand the record. But there is, as both parties represent to the court, and I see my time's expired, if I could just finish this answer.
Answering.
There is a live motion in the Superior Court to have her independently examined for competency, because yes, we do want to get her restored to competency. I'm not so sure the discharge to this unlocked residential facility is the answer, because even the defendant's experts are saying that her competency is somewhat organic. It's not going to change regardless of where she is. So the Commonwealth isn't sold.
Well, but if that's true, then you have to just dismiss the charges.
Well, if that is found to be true.
Yeah, if that's
yes.
true.
But Judge Massing, to answer your question, we're not sold that her discharge to this facility would suddenly restore her to competency. We think the next step is to litigate that in the Superior Court. So unless Your Honors have any further questions, I know we've covered a lot of ground, but I would rest on my brief.
No, it's a very, very complicated case, in my view. So thank you very much.
I meant to say, I agree there's a lot of interesting and thorny issues here, but at least in this appeal, on this posture, when you look at it from abuse of discretion or error of law, I don't think this court can find that either the single justice or Judge Yusayan committed those errors.
Okay, thank you very much for your argument.
Thank
Both
you.
sides, very, very difficult and interesting case. It is submitted, and that completes our sitting for this morning. I'd like to thank the court staff and in particular the court officer for their assistance, and we stand in recess. What have I hit there? So I keep doing...